Okay,
Okay,
I
I
I will begin my presentation. Thank you. As we know, China has been confronted with the Western concept of the international treaty and the rules under unfavorable historical situation. The perception of the government and the people about the relationship between China and the international law has consistently been passive and negative since the second half of 19th century. Across the last period of Qing dynasty, the period of Republic China, and the first 30 years since the establishment of the PRC. Only after China adopted the policy of reform and opening up, there appeared the rule on the application of the treaties within China in the related rules. The 1982 Civil Procedure Law set up a provision, Article 189, as follows: where an international treaty to which the People's Republic China is a contractor or assenting party provides otherwise, the provisions of the international treaty shall apply, with the exception of provisions on which the People's Republic China has declared reservation. And uh, there are a number of the laws and regulations. For example, the 1986 General Principle of Civil Law and the 1990 Administrative Procedure Law. A Chinese administrative, a Chinese professor has found that there are nearly 200 legislation, including laws and administrative regulations, which contains a similar provision. In this background, the traditional perception or the positive approach argued that international treaties are wholly incorporated into Chinese domestic legal system without being transferred into domestic law. This argument in favor of automatic standing incorporation of international rules are mainly based on the above-mentioned provisions, which provide for the application of treaty provision, where the related domestic law conflict with a treaty. This rule holds that treaties which bind PRC on the international level become part of the domestic law and are directly applicable by courts and the administration, which is similar to the concept of self-executing treaties in the United States practice. However, in recent 20 years, the traditional perception or the positive approach has been challenged more and more. First, the provisions which were regarded as the basis of the argument in favor of automatic standing incorporation of international rules has a limited scope of application. That is, they only apply in the field of the foreign-related matters, rather than all matters of the specific legal sector. Second, this provision only exists in part of legal system, especially in the sector of civil law, rather than all legal sector. For example, there is no such enabling provision in the field of criminal law. The traditional perception interpreted the enabling provisions which only existed in part of the legal system, by expanding their application scope to the whole legal system. On the basis of challenging traditional perception, the revised perception holds that the judgment whether an international treaty which China had concluded have the effect of direct application could only be decided by whether there is an enabling provision in a specific law. That is so-called the approach of enabling by legislation. This model entitled automatic incorporation of the treaties by an enabling provision concerning in a specific law, rather than enabling the domestic obligation of treaties in all fields. The Constitution of PRC has remained silent about the legal status of international law in the legal system of China. While the discussion on role of treaty and international law shall be established in the Constitution, only stayed in academic research. No step had been taken in the former process of legislation. It is worth to notice that there were also no legal rules or guidelines about the status of customary international law within the legal system of China. In light of the fact that there were no clear and consistent guidance about the status of international law within the legal system of China, it is not strange that when the officials in related authority or the judges in the courts consider the concept of acting according with law or rule of law, they normally understand it exclusively based on domestic law, rather than on the dimension of international law at the same time. On the contrary of positive approach, the due role and the proper application of international law in Chinese legal system were disregarded. We also concerned and disappointed about the trade that the approach of enabling by legislation has been marginalized in recent years. For example, when the Administrative Procedure Law was modified in 2017, the treaty application provision was deleted. The Civil Code, as a milestone in the rule of law in China, was formulated in 2020. But the treaty application provision, which were contained in the former global principle of civil law, disappeared. The lack of treaty application of provision provoked confusion and uncertainty for the judges and the lawyers, especially whether the international treaties could be applied in foreign related civil and commercial trials. It is possible that developing a proactive and friendly relationship between international treaties and the legal system of China, even if there exists no treaty application provision in a specific field. The WTO agreement is a good example. As far as the WTO agreement as concern, China adopted a combination of transformation as a mainstream means and incorporation as supplementary means. From the end of 1919 to the end of 2003, nearly 30 departments of the State Council sorted out more than 2,300 laws, regulations, and departmental rules. 14 rules were formulated and amended through the National People's Congress, NPC, and its Standing Committee. 38 administrative regulations were formulated and amended by the State Council, and 12 were abolished, and more than 1,000 departmental rules were formulated and abolished by the relevant departments of the State Council, and more than 190,000 sub-central regulations, rules, and other measures were sorted out and reversed or abolished respectively. The process, in no doubt, constituted of an unprecedented challenge for China. China was in a period of translation of economic system at that time, and there was still a huge gap between Chinese legal systems and administrative mechanism and the WTO agreements. As a new member, most of the gaps between Chinese legislation and the WTO agreements cannot be resolved through negotiation. Moreover, Chinese government also hoped to advance the establishment and improvement of the legal system of the socialist market economy by means of fulfilling WTO rules, which have been proved a huge success. The transformation as a mainstream means is also proved to be favorable to apply the WTO agreements in according with the actual conditions of the specific fields. So far, China has been challenged in 49 disputes by other WTO members. While a part of the disputes were resolved by means of consultation, most of the disputes went into the panel stage, and the ruling were adverse for China. Deputy Minister Wang Shouwen, Minister of Commerce, or PRC, had committed that as far as a WTO ruling is concerned, we will implement it, and there has no case in which the complaining member applied for retaliation due to China did not accept the WTO ruling. For example, after the dispute between the United States and China on intellectual property enforcement measures, the administrative regulation of China on custom protection of intellectual property rights were revised, and the Standing Committee of NPC also amended the copyright law in accordance with the ruling of WTO panel. In 2013, the Administration of Commerce also issued interim rules for the implementation of WTO rulings on trade remedies disputes. In June 2014, the General Office of the State Council issued a notice on further strengthening trade policy compliance, which established a WTO compliance review mechanism for legislation under Chinese foreign trade system. Chinese proactive engagement in the resolution of the trade disputes and its acceptance of the WTO rulings and amending domestic law and administrative measures in accordance with WTO rulings reflect a breakthrough of traditional perception of Chinese government about the relationship between international law and the state sovereignty. As China continues to participate in the dispute settlement process, the Chinese government become more confident to exploit legal measures to resolve trade disputes. And we could see the legal approach had become the culture prevailing in Chinese officials and lawyers in the field of trade. And according to President Xi Jinping, historical challenges have taken place in the relationship between China and the WTO. China has crossed the stairs of passive recipient and active adapter to international economic and trade rules to become an important participant in rulemaking. In recent years, China actively participates in global governance in an unprecedented manner, adopting international law into its domestic legal system with a more proactive and consistent manner could be contributable to promote the domestic reform process and the engagement in a global governance with more confidence. Moreover, Chinese government take efforts to advance the development of legal capacities in foreign-related affairs in an unprecedented manner. We could regard Article 29 of the Law on Foreign Relations as a footnote for this background. The state advances the rule of law in both domestic law and domestic and foreign affairs, and strengthens foreign-related legislative work and the system of rule of law in foreign affairs. This means that China need not only show a clear position on the relationship between international law and domestic law, especially the implementation and application of the treaties, but also establish the legal basis or declare legitimacy of measures with the purpose of counter the sanction or restriction measures imposed by the United States and other countries, to counter the illegal extraterritorial application of foreign law, and to suppress the intervention in inter affairs, especially the Taiwan issues. Then we could read the related provisions contained in the law of foreign affairs or foreign relations. In light of the fact that the law is the fundamental legislation in foreign affairs and related relations. It is significant to declare the position that China fulfills in good faith obligations stipulated in such treaties and agreements, and take due measures to implement and apply treaties and agreements to which it is a party. Although as a balanced test, the law emphasized the treaty and agreement shall not contravene the Constitution, and the implementation of and obligation of treaty agreement should not undermine the sovereignty of state, national security, and public interests. The core value of this provision in the current circumstance is to reaffirm the proactive position on the obligation of treaties. The provision did not follow the model of Article 142 of General Principle of Civil Law. As I have mentioned, the approach of enabling by legislation is applied and only applicable in a specific field. If the law of foreign relations adopted the similar provision as Article 142 of General Principle of Civil Law, the treaties would be adopted wholly in the legal system of China, which means a result amount to nearly to the means that the role of treaty and international law be established in the Constitution. It is obvious that Chinese government does not prepare for this legal effect. Some commentator criticized that the phrase of take due measure in Article 31 is too vague and broad. We could regard the provision as a result of balancing the debate between the view preferring direct application of treaties and the view of treaty in void. Take due measure means a position that a positive action deemed to be take, whatever the action could be automatic incorporation or transformation, or enabling the direct application by the means of legislation or standing commitment of NPC, or by the means of judicial interpretation or guidance of the Supreme Court, or enabling the direct application by the means of legislation or standing or the interpreting the related domestic law with the manner of consistent with international law. Rather, take due measure should not be passively read as omission. As Ambassador and Professor Huang Huikang had mentioned in other forum, the next step is to formulate the law on the obligation of treaties to clarify in more detail about the manners of application of treaty in China. It is interesting to notice that although the law of foreign relations did not provide the status of customary international law within the legal system of China, the law applied the fundamental principle of international law as the legal test or legal basis for take actions contained in Article 32 and Article 34. Due to the fundamental principle of international law could be regarded as customary international law. It could be read as customary international law has a role in the legal system of foreign affairs, although the role is limited. And according to Article 33, there are two elements for China to take measures to counter or take restrictive measures against foreign countries. Firstly, the acts of foreign countries violate international law or fundamental rules governing international relations. Secondly, the acts endanger Chinese sovereignty, national security, and development interests. Here, the legislation of the Act of Foreign Countries would be self-judged by China, rather than considered and judged by an international tribunal. This provision reflects the intent of automatic or unilateral application of international law, but there are potential risks that the measures would be challenged by the targeted country and arise more diplomatic conflicts. Okay, that's my presentation. Thank you very much. And your comments and opinions
Thank you very much,
will be
Prof.
highly
CHEN.
appreciated. Thank you.